Each party will have 15 minutes in which to argue their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, you wish to retain that time, please let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the front podium here as much as possible. We have read your briefs and we're ready to proceed when you are.
Thank you, Your Honor. May it please the court, I'm Attorney Jack Malicki. I represent the appellant and the counterclaim plaintiff in this case, Robert Tillman. We are here because Mr. Tillman was in default of his mortgage. Unfortunately, the default occurred at the direction of the lender. This all began before the note was ever in default. Mr. Tillman contacted the lender and asked for a loan modification. He was approved for a trial loan modification, whereby he was to pay approximately $600 per month versus his previous payment of $1,500 a month for approximately 7 months. And if he paid all those timely, then he was told he would get a permanent loan modification for approximately the $600. Mr. Tillman timely paid all of his payments, and when it came time for the permanent loan modification, the lender refused, rather than giving him approximately...
Can you move up to the front podium, please? I'm sorry to interrupt you. Thank you.
Rather than giving him the $600 monthly payment that had been agreed upon, they offered him to reduce his $1,500 payment by less than $7. Obviously, Mr. Tillman was not happy with this and did not accept it. For a period of time, payments were made where the lender was trying to figure out what they would do. Thereafter, the lender offered Mr. Tillman a forbearance agreement where the lender agreed that it would not foreclose on Mr. Tillman for a period of 6 months as long as he paid $800 per month during that time frame. Mr. Tillman timely paid the first 3 payments, but before the 4th payment was due, Lerner, Sampson, and Rothfuss, otherwise known as LSR, filed a foreclosure action on behalf of the lender. Mr. Tillman filed a pro se answer informing LSR that there was a forbearance agreement. And then thereafter, Mr. Tillman hired counsel and filed an amended answer and counterclaim, again informing LSR of the forbearance agreement. Thereafter, the lender filed a motion for summary judgment. That motion was denied by the trial court. The trial court held, quote, "There remain genuine issues of material fact in dispute, namely whether a forbearance agreement was entered into between plaintiff and defendant," end quote. Thereafter, the lender and Mr. Tillman settled their claims, but Mr. Tillman did not settle his claims with LSR. A consent judgment was entered, allowing the property to go to share sale as was agreed to by the lender and Mr. Tillman. The consent judgment did not address whether or not there was a forbearance agreement, and it did not address the claims against LSR. LSR filed a motion for summary judgment, and the trial court granted it without any analysis. Mr. Tillman timely appealed. In its motion for summary judgment, LSR argued that issue preclusion barred Mr. Tillman's claim, and 2, judicial estoppel barred Mr. Tillman's claim. However, it's abandoned the judicial estoppel argument on appeal. On appeal, LSR argues for the first time that Tillman's claim is barred because there's no case or controversy and therefore no standing and specifically no injury. And I believe I failed to reserve my 5 minutes. I apologize for doing now.
Thank you.
First, issue preclusion does not apply. Issue preclusion prevents parties from relitigating issues or facts that were litigated in a subsequent suit. From relitigating facts and issues in a subsequent suit that were fully litigated in a prior suit. Here, the facts and issues were not fully litigated. Those facts and issues being whether there was a forbearance agreement and whether LSR violated the Fair Debt Collection Practices Act. Issue preclusion requires that the fact or issue, 1, was actually and directly litigated in the prior action, 2, was passed upon and considered by a court of competent jurisdiction, and 3, when the party against whom issue preclusion is asserted was a party in privity with the party to the prior action. The first 2 elements are really what's at issue here. The facts and issues were of whether the forbearance agreement was in place and whether LSR violated the Fair Debt Collection Practices Act were preliminary litigated, as the lender's motion for summary judgment was denied based on the trial court ruling that there was the existence of the forbearance agreement remaining as a genuine issue of material fact in dispute. However, the existence of the forbearance agreement and whether LSR violated the Fair Debt Collection Practices Act was not fully litigated because the trial court never addressed it ever again. The only time it was ever addressed was when the motion for summary judgment filed by the lender was denied. consent judgment does not address it either. It does not address the forbearance agreement, nor does it address LSR's alleged FDCPA claim, or violation, I should say. Accordingly, those facts and issues were not passed upon by the trial court. Furthermore, the general rule is that the ruling should be from a prior action. Here, there is no prior action. While there are exceptions to the rule that there be a prior action, LSR has failed to establish that this is such a case. Finally, it would be against public policy and have a negative effect relative to settling with less than all parties to prevent Tillman from continuing to litigate his Fair Debt Collection Practices Act claim. It was clearly demonstrated in the mediation order that the claims against LSR were not settled. Those claims were not addressed whatsoever in the consent judgment. And
Counsel, let's go over what was in the consent judgment.
Okay.
Okay. No, that's okay. So, in the consent judgment, your client agreed that it was in default.
Yes, I agreed when he was in default when he signed the forbearance agreement as well.
Okay. And, well, there was a disagreement, though, over that, right? Because he thought he was under a trial program where he was paying a lesser amount, a loan modification.
Well, the trial payment period is a step before your loan is actually changed and transferred to the new payment. So until you get the permanent loan modification, you technically don't have a deal. I mean, it's a mortgage, and statute of frauds requires that it be in writing. So the payments were made timely, but then the bank didn't follow through. Apparently, at this point in time, which was some years ago, they didn't fully vet all of the income and stuff to make sure that you qualified for what they were approving you for, and when they went back through it, they determined that he didn't qualify for what they had offered him in the first place. But none of that was explained to my client. And so the default occurred because he's paying $600 a month when under the note he's required to pay $1,500 a month for a 7-month period. So that's about $6,300 that he's going to be short.
Right, but the whole point I'm getting at is that was the whole point of the forbearance agreement, was because your client was basically saying, you know, you didn't abide by your representations to me, and I should be paying a lesser amount because that was our agreement.
None of that would be found in the forbearance agreement. The forbearance agreement is drafted by the bank.
Okay.
My client's barely literate. I'm sure there's nothing in there that helps him at all.
I'm just going by what your arguments are, because I thought the whole point of you informing us of this prior arrangement and everything was to show how your client was not in default. But there came to be a point in time, regardless, there came to be a point in time where they entered into a consent judgment whereby they did agree that they were in default, okay, and that the bank could foreclose,
Yes,
right? And it was eventually, there was eventually a sheriff's sale.
that's correct.
Okay, so I guess I'm just not understanding if your client is saying that the bank could rightfully foreclose, why there is a violation of the Fair Debt Practices Act.
The bank had a right to foreclose because my client was in default. They approached my client and they said, we're going to foreclose on you, or else you need to agree to this forbearance agreement and pay us $800 a month.
Mhm.
And he made an agreement with the bank that he was in default, that he would pay $800 a month with the hope that they could work something out after the end of the forbearance period. And a foreclosure case was filed in the middle of the 6-month period and robbed him of 3 months of time that he had with no foreclosure against him.
So an argument could be made that he shouldn't have agreed to allow the bank to foreclose.
Argument could be made. Well, I mean, we settled the case. Ultimately, my client's in default. I think likely he could have won the case against the bank, but the bank would have just filed another foreclosure and then won because there wouldn't have been a second forbearance in place. So rather than making 2 cases happen, my client and the bank agreed to a deal, and there was a consent order.
Right. I understand that. I'm just trying to figure out why this isn't, I know you're making the legal argument in regard to you can't have an issue preclusion in the same case, or it's not appropriate here at least. But I'm trying to figure out why issue preclusion, other than the fact that, you know, that if this were a subsequent case, well, let me ask you this. Would you agree if this were a subsequent case that issue preclusion would apply?
If there was a ruling as to whether or not there was a forbearance agreement in the case. So let's say that we had pursued the case and we had won against the lender, and a case was dismissed because there was a forbearance agreement, in there, then the issue preclusion would be against LSR because it would have been decided in my client's favor. But we never went that far. We agreed to settle the case, and part of that agreement was to allow the lender to have a foreclosure or sheriff's sale. So we had to sign a judgment to allow that to occur. But we specifically withheld our claims against LSR and did not anywhere in the document state that there was no forbearance or anything along those lines. The forbearance agreement was never really ruled on. The only time it was ruled upon was that there was a material issue of fact. In the consent order, there's nothing, no, the word forbearance agreement does not appear one time.
Thank you.
You have 5 minutes and 24 seconds. Well, 5 minutes if you want to stop now.
Quickly, case and controversy and standing. I think you guys have heard enough, I shouldn't say you guys, I'm sorry. Sure, the court has heard enough argument on the Fair Debt Collection Practices Act that I don't need to go into that too much. But as far as case and controversy and standing, standing is determined at the time of the filing of the action. So here that would be the filing of the counterclaim, and clearly the consent order happened after that. Additionally, when he's saying there's no damages, there were damages for the loss of the 3 months of the forbearance period. Attorney's fees were paid, filing fees were paid, and lost wages occurred because of attending trial court things. And he's also suffered mental anguish, which he's never provided an opportunity to present that evidence at the trial level because the injury issue was raised for the first time on appeal. I'd like to reserve the rest of my time.
Thank you.
Good morning, may it please the court. My name is Rick DeBlasis, and I am counsel for the appellee Lorain Sampson and office. This case is a very unusual case because the argument is not whether the bank and the borrower had a dispute in a foreclosure. This case is about whether the bank's lawyer filed a false and misleading complaint when that complaint was found to be true and accurate. LSR pled in its complaint that the loan was in default. LSR did not plead anything regarding a forbearance agreement. The simple matter, and this court has seen plenty of foreclosure complaints. The foreclosure complaint alleges the loan is in default. The trial court found, and I'm reading directly from the consent entry, the trial court found said conditions in the mortgage deed have been broken by reason of non-payment, and the same has become absolute, and that the plaintiff is entitled to have the equity of redemption and the dower of all defendants foreclosed. The court finds no further reason for delay in entering judgment for the plaintiff. The court finds on evidence adduced that there is due the plaintiff on the promissory note as modified as set forth in the complaint, the sum of $164,000 and some change, for which sum judgment is hereby rendered against defendant and in favor of plaintiff. In other words, the court found exactly what was pled in the complaint to be true. And yet, the case before you is whether that complaint is false and misleading. It can't be.
Counsel, what was the time period, 6 months for the forbearance agreement?
There was apparently a forbearance in place, and it had I believe that's right, a 6-month payment plan.
Well, that was introduced in evidence, the forbearance agreement, right?
Correct.
Okay. So 6 months, and there's not a dispute that the complaint was filed during that period?
That's correct.
Okay. When was the consent entry entered?
Some years later.
So that would have been after the forbearance period would have expired?
Yes.
Okay. So maybe the issue is not so much that they were ultimately in default, but that the firm should not have filed the complaint for foreclosure during that forbearance period, which the trial court did not really consider.
Well, that's right, and I think what you just heard from the appellant is that there was a genuine issue of material fact as to whether this forbearance agreement was in place. And that is exactly what lawyers are supposed to bring to the court, genuine issues of material fact. In other words, the appellant would like you to believe there was a forbearance agreement in place, but according to the bank, in order for the forbearance agreement to be put in place, it needed to be signed and returned to the bank. Mm-hmm. That was never done. Mm-hmm. So was the forbearance agreement in place? Well, the appellant would like you to think it was. appellee, we're the appellee, but the bank would like you to think it wasn't. Now, there's a genuine issue of material fact. What are we supposed to do with a genuine issue of material fact? We're supposed to bring it to the court for decision. And that was what the foreclosure complaint did. Foreclosure complaint brings a legitimate dispute to the court for decision. If counsel for the bank is going to be in fear of a FDCPA complaint every time they bring a legitimate issue of material fact to the court, what have we done to the legal system with the FDCPA? We've used it to clobber good faith complaints to the court. This complaint was actually found to be true by a consent decree. Where is the line about what a legitimate lawyer can do for the bank? Interestingly, I just like the way you phrase this. It would be contradictory for a court to rule that the allegations of a complaint are true, and then to find that the counsel that made them was engaged in false, misleading, and deceptive conduct. The complaint was true, and yet we're being accused of false, deceptive, and misleading conduct for making the allegations in the complaint. The court cannot enter a judgment for the plaintiff, granting the plaintiff all of the relief it seeks, and then hold its counsel liable for seeking it. Helen wants you to consider public policy. So does appellee. What is the public policy if we hold counsel liable for an FDCPA violation here? And in fact, it's demonstrated in this case. Isn't it the next phase of foreclosure litigation for the borrower to sue plaintiff's counsel? Let's bring plaintiff's counsel into the suit. Number one, it disqualifies them, at least in the eyes of the bank, so that you have disqualified plaintiff's counsel, chosen counsel. Number two, if the case should be settled, like this case was, with a consent decree of all things, or the plaintiff should lose its case for any reason, now counsel has a legitimate risk of being held liable for an FDCPA violation. There's nothing in this complaint that crosses the line. There's nothing in this complaint but a request that the court find that the borrower was in default for payment. That is a legitimate issue in this case. You just heard counsel for the appellant say there was a genuine issue of material fact whether a forbearance agreement was in place. So, if there's a genuine issue, if there is anything, I don't know how many different ways I can say this, if there was anything to settle, counsel just said that the parties settled, the bank and the borrower settled the case. Well, the very implication of settlement is that the parties each had a valid point to make, so that they had to settle them. If there was something to settle, then there was a dispute of some sort that should be brought to court. Okay, I said that there was something in this case that points this up. After our firm was sued, then Graydon, Head and Ritchie, another firm, came in to represent Citi. And guess what's in the record there? The defendant sued Graydon, Head and Ritchie. Well, he sought to bring them in as another counterclaim defendant in the case, because they picked up the same representation of the bank that the defendant says they didn't have a claim against them. So the implication is any lawyer that seeks to represent the bank is also committing an FDCPA violation. Well, the trial court heard too much of that claim and said, no, you can't also sue Graydon, Head and Ritchie, because if you did that, then the bank would not have any representation. No one could represent the bank, and banks, of course, have to have counsel in the case. So it points exactly that issue, and the issue is, what is the line for when counsel can bring a good faith case on behalf of his client to the court without living in fear of being sued for an FDCPA violation. The FDCPA, as we well know, prohibits false representation of the character, amount, or legal status of any debt. Well, the representation of the legal status of this debt was that it was in default, and the court found that. The trial court found that it was in default. This court would have to, if this court holds as appellant would like it to do, that's to say that there is a possibility of an FDCPA violation here, then you've got a final judgment of the trial court saying the complaint is accurate and true. And you've also got an FDCPA, a possible FDCPA violation by the legal counsel that brought it. That is confusing to the public. That is not the way the law is supposed to work. You can't have a complaint that's true and then also sue the counsel for bringing it.
Well, and I understand what you're saying, but I guess where I'm still having the hard time is with the complaint. Obviously, I'm not sure that anybody's contesting that the allegations in the complaint were not true. It's just a matter of whether, like you said, there was an agreement in place that you not proceed on those true allegations at that point.
Well, I understand that, Your Honor. The question is whether that agreement was in place. The bank says it was not in place. The bank's letter, which is in the record, and the agreement itself both provide you must sign and return this or it will be void and unenforceable.
Was that alleged in the complaint?
I'm sorry?
Was that alleged in the complaint, that they were not returned?
No, there was no evidence in the complaint of the forbearance agreement. The forbearance agreement was only brought up after the complaint was filed.
And how was that brought up? I can't remember.
It was brought up by the defendant in his answer.
That's what I'm saying. That's what I
Yes.
couldn't remember. I thought it was an answer, but I couldn't remember.
Right, there's no evidence in the record that the forbearance agreement was known to anyone prior to the complaint.
There's no signed document by both parties consenting to a forbearance agreement.
That is
what you're
correct.
telling me.
That is correct. What happened is that the borrower simply started making payments, but the forbearance agreement itself, as sent by the bank, was very specific. You must sign and return this to be enforceable. And it says, the agreement itself says, you must sign and return, quote, or this agreement will be considered null and void and we will resume collection and or foreclosure activity if applicable. That's in the affidavit of Jennifer Sherman, which is the transcript of documents 59, and it's in her paragraphs 11 and 12, and her Exhibit C. Her Exhibit C to that affidavit is a copy of this letter and the forbearance agreement, and it clearly says, if you don't sign it and return it, it's void and unenforceable. Now they would, and really, even here today, appellant is only saying there was a genuine issue of material fact as to whether this agreement was enforced. Wants to say, I could orally accept it. Okay, I get it. But that's a genuine issue of fact, which should be brought to the court for solution. And that's all we did. And then the consent decree, in our view, closes the door. The property's already been
Well,
sold.
how do you bring it to the courts? How do you bring it to the court for resolution if you don't mention it in your complaint?
I'm sorry.
How did you bring it to the court for resolution if you didn't mention it in your complaint?
Well, the forbearance, there was no forbearance agreement.
Well, I understand,
Yes.
that's what you're saying, but you keep saying there's an issue of fact, that's all anybody.
Well, no, I think that's what appellants say.
Okay, all right, but the point is, if there's an issue of fact, you say you bring to the court for resolution. And I'm like, well, I'm not sure I understand that, because it sounds like that's what the appellant was doing, not the appellee.
That's right, but so if we're gonna take that to the point of an FDCPA violation, what you've done now is you have raised the pleading level beyond notice pleading. The implication of following that to the conclusion is that you must, in your foreclosure complaint, you must anticipate all of the defenses that may be made by the defendant, and you must plead that those are not true, or there's a legitimate dispute about them. That's not the way pleading goes. The Supreme Court just held, I think it was in the Horn case, just said, no, wait a minute, you don't have to attach the right version of the promissory note to the complaint. You don't have to attach a payment history to the complaint. Pleading is notice pleading in Ohio. Supreme Court said we've gotten a little away from notice pleading. If I plead that the defendant is in default under a note and a mortgage, which we hold, that under the Supreme Court guidance is sufficient. And then if the defendant has a defense, which as the court is suggesting, a forbearance agreement may very well be a defense, then it is up to the defendant to come forward with affirmative defenses and then for the court to resolve the dispute. That is what happened here. I wouldn't know how to phrase a foreclosure complaint anymore. If I have to investigate, which
I'm not suggesting that. I'm just going by your rationale that
Right.
you bring it to the court for the court's resolution.
and I know you're not suggesting, this is
Yeah.
debate, this is what we do. I'm probably out of time. I think you've been very patient with me. Thank you very much.
Thank you. You have just over 4 minutes.
Thank you. I guess there was a case pointed out in my brief, I forget the name of it at this point in time, but there was a case where the attorney brought a claim against a debtor claiming that pursuant to the contract, they were entitled to attorney's fees and asked for those attorney's fees. The court didn't award the attorney's fees, and then they said, well, then there can't be any violation because there's no damages. The court said there are damages and you have violated because you asked for relief you can't get. And even though you didn't get it, you still violated the act. The act is the Fair Debt Collection Practices Act is a strict liability act. If you allege that you can do something when you can't do it, such as filing a foreclosure when a forbearance is in place, you have violated the act. Now there is what's called the bona fide heirs defense, but that shifts the burden of fact over to the defendant in the fair debt claim to show that we have procedures in place and that we followed those procedures and that we should have caught this, but even though we have the procedures in place and we followed them, it slipped through the cracks, so please, we're sorry. There's been no evidence presented as to their procedures or what they did or didn't do in this case at all. We never got that far. And you know, the trial court's already determined there's a genuine issue of material fact, so whether or not there is a forbearance agreement in place. So really arguing about it here, I don't know if that gets us anywhere. The court never ruled on it finally thereafter.
Well, and I was just going to ask you that, so that was a good segue. Why do you keep saying the court never ruled on it?
Because the consent entry was not relative to any claims against LSR. It does not mention the forbearance agreement in it one time, and it doesn't mention any of the fair debt claims against LSR.
But that was your argument at trial in regard to the summary judgment motion.
In the trial court, you mean?
Mm-hmm.
I'm sorry, that was my argument. Yes, my argument was that there was a forbearance agreement in place.
And the court ruled against you?
We settled a claim and we
No,
agreed.
I'm talking about in regard to the Fair Debt Collection Act. The court ruled against you.
No. The court, well, when they filed their motion for summary judgment.
Yeah, that's what I'm saying.
Okay, the court ruled against us without any analysis whatsoever, but.
That's a different issue. That's what I'm getting you to, okay? Okay, wait, just bear with me for a second. I know you want to talk, and I appreciate that because I was an attorney too. I guess I still am. But anyway, my point is, the trial court ruled against they filed a motion for summary judgment. Okay. And I know you argued there was a forbearance agreement, so they were in violation of the Fair Debt Act, right?
Not in those briefings.
Okay. All right.
LSR never argued there was no forbearance agreement. They said this is res judicata. I told you the two issues. They're issue preclusion and res judicata.
Okay.
They're the only two things they argued.
Okay, I'm getting confused with the first one then.
So they never decided, and the LSR never argued relative to the fair debt collection practice, or I'm sorry, relative to the forbearance agreement. They just said because there's a consent entry, and as you said, you granted the complaint basically as it was filed.
And they said there was a consent entry, and
Yes.
that's the reason for summary judgment.
That's what LSR argued. The
Yeah.
court had no analysis, so I
I
have no idea.
know,
what
we're talking around in circles. I apologize. What did you argue in regard to the consent entry?
I argued that issue preclusion did not apply.
Mhm.
I argued that res judicata did not apply.
Mhm.
And I did argue relative to the Fair Debt Collection Practices Act that it applies to them. But there really was no, LSR never opposed the fact that the court's already found that there is a,
Well, that's not what I'm asking you. I'm asking what you argued when they said that they were entitled to summary judgment.
I argued that the court has already found that there is an issue of material fact as to the.
Okay, then that's what I said to begin with, and you said that wasn't argued.
It wasn't re-argued, it was just pointed out that it was already decided there's a genuine issue of material.
All right, we're
fact.
just talking, different views on what argument means, so, okay.
Okay. So I don't know.
I didn't mean to take up so much of your time, I apologize, I was just misunderstanding something evidently.
And the crux of this is the complaint alleges they're entitled to foreclose right now when they file it. And that's false and misleading, it's wrong. There's a forbearance agreement in place. That is the violation.
So it seems to me that the genuine issue of material fact is, did your client sign it and send it back?
The facts bore out this way, that there was a cover letter, which parole evidence would preclude, that says you have to sign and return it. Forbearance agreement does not say that. The bank sends these things to you when they give you a few days to get them back. My client called the bank and said, listen, I have this forbearance agreement, I'd like to agree to it, I don't think I can get it back to you by the deadline, can I agree to it verbally and set up payment plan now? He was told yes. He did that, and the bank accepted 3 of those payments before they decided to foreclose. If they would have accepted none and foreclosed or 1 and foreclosed, then I think they would have a better argument that we didn't have a deal. But to be halfway through the deal before you decide, no, I don't like this deal anymore, I'm going to foreclose anyway, I don't think that's fair or complies with the law at all.
Okay, and with that, sir, you're out of time.
Thank you.
Thank you much for your presentations today. The court will take the matter under
Thank you.
advisement and issue a written decision, which will be mailed to both sides as well as posted to our website, and that is Supreme Court.